in the agenda. So first I'll go to the About Me page. I'll talk a little bit about me and give you a little bit of history of what I've done in this industry before and where I come from. So we'll get to know each other a little bit better. And then I'll go to the introduction to GDPR so that you have some understanding of what it is if you're new to it. And then we'll talk about the challenges. We'll talk about what GDPR news are today and what are the lessons learned so far since May 2018. And then we will talk about the quick wins. So what to do to get it started as soon as possible. Some low-hanging fruits that you can implement. And then I'll briefly talk about the GDPR tools and resources that are helpful. Most of them are open source and free, and I think I have one that is very cheap that I'm suggesting, but I'm not an affiliate of it. So anyway, I will put that out there as well. About questions, please mute yourself and then use the chat box. So I will get to the chat box later at the time of the questions. I'll go through them and make sure that I answer the questions you have. Okay. So a little bit about me. I've been in IT security and privacy and compliance for the past 14 years. I've done GDPR for almost 2 and a bit years. So from the very beginning, before it actually was implemented, of course, I helped a few public and private organizations with their GDPR needs before it was implemented, and now after May 2018 as well. As everybody knows, it's a live and breathing program, so it's not a one-off compliance. So I'm still working in this space. I am certified as CISSP, CCSP, which is for cloud security. I am certified as CISM, security management, CH for ethical hacking, and SATSA, which is security architecture. Just so you know, because this is a privacy topic, I wanted to put it out there that I'm not a lawyer, nor have I had any legal education. So please keep that in mind. It's always great to reach out to your corporate lawyers and get some consultants on your privacy needs as well. So I definitely encourage that, even after this session. So for myself, I have had my own company, my own incorporated company called InfoSec Assured since 2015. I'm an independent consultant there, and I have many different clients. Okay, so that was about me. Now let's get to GDPR Intro. So GDPR has a few principles that I'm going to go over. So one is called lawfulness, fairness, and transparency. That's basically the consent you get from people. Basically that means that you tell them that this is why I need it. The why is very important. So it needs to be lawful, it needs to be fair, it needs to be transparent. So in your consent, you need to be very transparent about why you're collecting this information. And the other one is purpose limitation, same thing, but the key word here is limitation. So you limit the purpose of collecting personal identifiable information, which I refer to it as PII from here on. You limit it as much as possible. That's another principle. The other principle is data minimization. So basically you minimal, and the data that you get has to be really minimal. And you collect as much as you need, and only for that purpose. And the data needs to be accurate. So you have to give your clients, your audience, to have a chance to update their privacy information. So whatever PII you have on them, they need to be able to update it. So say they've given you their physical address, they need to make sure that they can update it if they go to they move. Storage limitation. So again, you store as much as you need for as long as you need. So the retention policy is very important here. The other principle is called integrity and confidentiality and security, obviously. So again, the data is accurate and also it is kept confidential. And only the people who need to see it are able to see it. And also accountability is important so that the data is traceable. You can see who has done what with the data and why. And there's a timeline so that you can trace it back if in case of a breach. GDPR is designed to give EU citizens more confidence and control over their PII. Again, it's personal identifiable information. It applies to any organization or all the organizations that are in the EU, European Union, and also any organization that is outside of the EU but is marketing and offering services and products to the EU citizens or businesses as well. There are two types of data handlers within GDPR that you need to be aware of. One is called controllers, the other one is called processors. So controllers, you can really think about it as the business owner. So the person or public authority or agency or any other type of entity that understands the business model and based on the business model needs to collect PII. So the purpose of that PII collection is determined by the controller. The processor, however, is the person or the company or agency or any other entity that actually processes the data on behalf of the controller. So they actually are the people or the organizations that are manipulating the data, they're working with the data, and so their liability there is much higher for processors usually. Any information, so now I want to talk about a little bit about in GDPR, what is considered PII or personally identifiable information. So as it says, PII is any type of information that would identify a person, would pinpoint a person, and would differentiate one person from the other. So that would be name, first name, last name. Physical email address, photos, any other media, videos, genetic data, biometric data, even IP addresses, cookies. In GDPR, cookies are also considered PII. Children's data is something that has come up with GDPR, and GDPR considers PII. So children's data is considered PII, and children below 16 years old, they need parental consent. So you need to have two separate consents for these, for children and people above 16 years old, unless you're not actually marketing to children, or you're not providing them products, and you have a little checkpoint somewhere saying that yes, I'm older than 16 or something like that. And then also religious beliefs and ethnicity and political beliefs is also considered PII. Now, bear in mind that if you're pseudonymizing the data, so that it's not pinpointing one person, does not identify one person, that is not called PII anymore. So that is one of the ways that you can go around it. Next thing is about breach notification rules. So the breach must be reported to the relevant supervisory bodies within 72 hours of the organization first becoming aware of it. So few things here. First 72 hours is very crucial from the time that you're aware of it. Not the time that you actually confirm. So 72 hours from when you're aware of the breach. Also, who are the supervisory bodies? And they are basically supervisory authorities, which means that there are independent public authorities which they're established by a member state, And they should, upon request, provide information to any data subject concerning the exercise of their rights. So their data subjects are basically people who have given you their PII. Supervisory authorities should handle complaints of the data subject, inform them of the progress and the outcome of the investigation within a reasonable period. And again, reasonable period here is not really defined. Then non-compliance fines is something that got everybody super worried when GDPR started. The maximum fine of 20 million euros or 4% of worldwide turnover, whatever or whichever that is greater, is for the infringement of the rights of the data subjects, unauthorized international transfer of personal data, and failure to procedures in place or ignoring subject access requests for their data. And there's also a lower fine of 10 million euros to 2% of worldwide turnover will be applied to companies which mishandle the data in other ways. And they include, but they may not be limited to, failure to report a data breach, failure to build in privacy by design and ensure data protection is applied in the first stage of a project. Okay, now about GDPR complaints and investigations. So GDPR doesn't audit you. So there's no audit for GDPR. They may actually come up with a certification process later on, but haven't come up with that yet. So there's no audit in place for GDPR. You basically, when you say you're GDPR compliant, or you're expected to be compliant anyway, but then you don't follow it properly, and then if a client of yours or your employee or whoever you have their PII, they may file a complaint about you, and then that kicks off an investigation by the supervisory authorities. So that's how, and that's how you start getting investigated. So as GDPR challenges now, there are too many requests and client calls. So what do we mean by that? One of the GDPR requirements is, as we said, the data needs to be accurate. The integrity of the data needs to be kept. The data needs to be updated. So the client will call you or may make a request to update their data. That's the easy one, actually. The harder one is the right to be forgotten. So the clients may actually ask you that I want my data to be removed, my PII to be removed from your systems, all your downstream systems, or your emails, this, that, everything, right? So that is a huge concern and huge overhead for a lot of companies now, and to handle all those calls and requests. Another challenge is that PII sometimes gets really hard to identify, where they're coming from, and what are the sources, because before they wouldn't look at it this way. So now they have to go back to the historical data sources and understand where everybody has to understand where they're collecting data, where they're storing data, how long they're storing the data for, where are they storing consent, how long they keep the consent for, do they have a mechanism to actually update the consent. So all of that is one of the huge challenges. As part of my experience, this was by far the biggest challenge we had with PII, especially within the companies that are that have been around for a longer time. So there is impact on vendors' communications. So vendors may actually have, you may need to go back to your vendors and understand what they're doing and how they're how they're actually handling your PII or the PII you're sending to them. For example, if you're using AWS, for example, Amazon Web Services, then in that case, and you're using their S3 bucket, which is basically a storage for data, then you say, if you're uploading your PII to Amazon Web Services, then in that case, you need to make sure that they're handling PII properly on behalf of you. There will be overlapping requirements between security and privacy, which is sometimes it's very good, and sometimes it makes it harder for people because there are different priorities. So always, in my experience, audit and compliance requirements that would lead to non-compliance fines would get the priority. Which may not be 100% good, right? Because a lot of times privacy and laws and regulations, be it in privacy and security, they are actually giving you the baseline of what you need to do. So it's the bare minimum. It's just best practices, really. So if you want to be more secure, you can do a lot more within within your environment. So you can actually bump up your requirements much more, but then sometimes, as I said, compliance may take the priority. Impact on employment engagement letter. So a lot of times people forget about their employees that are EU citizens, or they're from EU offices. And they forget. So they think that GDPR is only for clients and customers, not for their employees or contractors or vendors or everybody else. So basically, any person, regardless of what the channel was, regardless of if it was from your HR systems, if it was from your CRM system, so it was your client, if it was from your website, if it was from your vendor, and they're actually lending you some employees, and so you have PII information on them, whatever the case may be. And do not forget about other types of PII you have. Don't only go to your clients or customers. The other challenge is ongoing training. So with anything to do with security and privacy comes down to awareness a lot, right? So awareness and training, is a huge player in your success for GDPR compliance, or not to have any breaches in general, right? So that's your best bet. You have to really spend time, effort, money on training and invest on it, because that's probably the biggest thing you can do for your company is ongoing training. But then it also becomes very challenging because because you need to always keep it interesting. You have to make it relevant to the audience. So there is a lot of work, and training, it does not come easy or without cost or time cost anyway. Also, because of all the other reasons that I just explained, there will be costs to GDPR. And other than that, there's also cost to hiring a data protection officer, right? And so, that's also a requirement for GDPR to hire a data protection officer. You don't have to hire. You can just appoint a data protection officer within your office, and or they can take on DPO as well. And somebody else can take on, like, for example, your CISO, your Chief of Information Security Officer, could actually take on your DPO role as well. So, but there may be cost to it if you have to hire, because your privacy work is so much that you need a separate person. And of course, handling all these, client calls and requests, as I said, and also, implementing the requirements and also the training may actually cost you money and time as well. Now, I want to talk about the fun part, which is the recent news and the lessons learned on GDPR. Everybody knows that GDPR came to effect since May 2018. So it hasn't been so long. We don't have so many things to talk about, but still it is very interesting to see what has happened. A lot of people, a lot of the companies and organizations, took GDPR differently. So I've seen companies where they said, I'm going to wait till GDPR comes to effect, and then I see some of the fines and see how companies are dealing with them, and then I'll go and implement. Or I see, how important this is and how much they're actually fining people on, how much this thing is actually, is it a big deal or not? I will do it then. There were other companies where they got ahead of the game, and then they spent a lot of money. They did a lot of work, and very good on them. But then when they saw some of the other people implementing it, far easier, far less detailed, and they're getting away with it. So it's always a guesswork, I guess, until any standard and regulation matures a little bit. So this obviously is a very new one, and of course it's built on previous privacy laws and legislations, but still a lot of the requirements are new. So anyway, so since May 2018, they did some statistics around what has happened in the world, and how many breaches there were, and how many companies got fined and what kind of fines and stuff like that. So the statistics was done in February 2019. So 8-9 months after May 2018, and there were almost 60,000 data breaches that have been reported, but there were only about 90-something fines, so a little bit less than 100 fines, or 100 companies that got fined. So that was really interesting. So they let a lot of people go, a lot of companies go, although there were breaches. Now it's unknown if those companies will get their fines later on, or they're still under investigation, or what is causing this, or maybe the impact wasn't that huge on the client's data, or the impact wasn't that bad, so that's why they didn't get fined. It's interesting to note that Netherlands, Germany, and the United Kingdom are leading these reports so far. So the breach reports, by far from the other countries. So the guess here is that the regulators or the supervisory authorities are actually stretching thin, because they have to do so much, and they have to deal with a lot of breaches. They have to deal with a lot of investigation cases, with a lot of data subject complaints. So that's why they're probably not getting to all the data breaches, and they are only following up on the ones that are very impactful. But although they're stretching thin, something we've noticed is that they're not only going after the big fish. Also smaller companies, they are involved. So basically, fines are not based on the size of the business, or it's not based on, if I have 100 people company, right? I have a very small business, and maybe it's only a $10 million business. But I don't get fined based on the size of my business. So I get fined based on the size of the impact on the data subjects and PII and privacy. That is something that we need to keep in mind. So this can be, for example, like say you have a very small cleaning company, right? So it's a very small cleaning company, but you've actually landed a big contract with, say, a big bank, right? And then the breach has happened because of one of the cleaners has gone to a data center to clean the data center and kept the door open, or whatever the case is, right? And then something has gotten stolen and there is a breach now. So your company may be very small, but you have caused something very huge. And it goes back to the contracts between you and the bank to understand who takes the liability. So this is the stuff that you need to think about, although you have a small company, that you still have to get ahead of the game. Something that has been learned is that it's very important to demonstrate effort and cooperation. So as long as you're cooperating with the investigators and you're cooperating, showing that you have done your due diligence, you have done your due care, and you've done as much as you could, and also you have identified the risks, although you may not have remediated the risks right away, and hence you had breach, but you have shown that you had identified the risks, you had a process to identify, you had a process to remediate, you have done your effort, you've done your work with as much as you could. And that having the good in your heart makes a huge difference in the investigation results. There are some bare minimum basics that is best and has shown that would help with the breach, which is password encryption and hashing, access control in general, data protection in general, data retention, pseudonymization, and minimization. These are very, very important. At a very minimum, make sure you've got this covered. We will get to that a little bit in more details later on. The other thing that would really help with investigations is that you show that you have been transparent with your customers in the details of your consent. So the consent that you have asked for in your consent, in the privacy statement, you actually say in details why you're collecting the data, how you're collecting the data, what you do with the data, and where you store the data, how long you keep the data, and how you destroy the data. That is very, very important, that you kind of give your customer this life cycle of their PII, and then be very transparent about it. This really comes handy in your investigations if, God forbid, there is any breach. There are some important GDPR articles that articles meaning like clause, that you need to really focus on, and that's right to be forgotten. So if you have that is very, very good and will help you with investigation, because a lot of the complaints are about right to be forgotten. So somebody has asked that, and then the company has actually not been able to deliver on that front. So they actually have not removed the PII data. So that's why there's a complaint. So make sure you're good on that front, and then you have privacy by design and by default. So what does that mean? That means that every project that is going live, before it goes live, you have the perfect privacy impact assessment done. So that is one of the requirements for GDPR. So you need to have a process that would work on your ongoing projects. I will talk about this a little bit more in more details now. Okay, so now let's talk about the quick wins. So something that is very important for privacy, for compliance, and for security in general, very, very important, is that you fully understand your business model. Why do we say that? Because we want to know, based on the business model, what is it that you need to have as the PII from a person? And what kind of person do you need this PII from? So who's your niche market? And why do you need this? If you're marketing this to them, what are they getting? And how long are you marketing this to them? And once the marketing is done, then what do you do with PII? And like from the business perspective, what is it that you need, and why do you need it? Why do you need to process? Why do you need to store PII? And the answer to that would clarify a lot of the answers to the rest of your GDPR roadmap and questions. Next thing to do is update your privacy policy. This is a very easy thing to do, right? Just take your privacy policy from your website and make sure it's updated based on, again, how you collect PII, why you collect PII, the purpose, the length of the time you keep it, where you store it, where you're processing it in terms of the countries or data centers, and what you're doing with it, how long you keep it, how you destroy it, how they can update their privacy and things, their PII and things like that. Something that I've seen people doing, and it's very good and has helped them a lot, is to develop a GDPR frequent. This is very helpful, trust me, because also for the requests on PII from the data subject, you can actually use this a lot. You can send this to them because a lot of times, the data subject may actually ask about, what type of data do you have on me? And then that usually or only you get first name, last name, email, for example, from any client. So he or she would not be any different, right? If say the request was in an email, it's best to answer that way and just say, we have your name, email, and phone number and physical address, for example, instead of saying we have, John Doe, and your email johndoe@gmail.com. Your number is 555-555-5555. Instead of all of this, it's better to do it that way because then you have to, because you're actually putting PII in that email as well. So it's very important to have it this way. And you can actually send them to your GDPR frequently asked questions as well, which could also be your privacy policy, but in a different format. You know what I mean? So you're basically giving them the same type of information that you would give to privacy policy, but in their words, you would ask the question, and in their words, you would answer, which is very important. And this will actually, if there's any investigation, if there's any breach, this will show how much you've gone, out of your way to make sure they understand this. So the other thing is reach out to your existing clients, and that's something that you have to do. So if you have historical existing clients, don't forget about them. You need to communicate with them that now you're GDPR compliant. This is what you're doing. This is what you're collecting. Blah blah blah. Same thing, right? And you have to make sure you have clear consent. So this clear consent is the same things that in your privacy policy, again, the what, the how, the purpose, and stuff like that. But make sure you're also including parental consent or a checkbox saying that I'm older than 16, right? And also you have a way of updating your consent. So within your website, if you're collecting consent from website, for example, you need to make sure that you have a method to actually update your consent. retain that consent for as long as that client or that person or employee is with you. Inventory your PII. This is probably the most time-consuming piece, at least in my experience. That was the most time-consuming piece. So inventory it, make sure that you know where it's coming from, and you know what type of PII there are, which database has it, which data center is stored in, and you know, and all that kind of stuff. You can scan for hidden PII in all environments, and you have to follow it through your downstream systems and service providers. So a data flow is very important, right? So not only the collection, but then where it goes, even your cache, even your emails, even the pictures, and all that kind of stuff is very important. And there are a lot of tools that I will talk about shortly that would scan your PII. And so you can actually see where you have PII and you know, stuff that is hidden or stuff places where you did not expect. And trust me, that happens a lot. Like for example, in the emails, right, or spreadsheets or Word documents on everybody's laptops and desktops. So it is very important that you do automize this scanning piece. Develop data protection policy and procedures. That is also a bit time consuming because you know, developing it and knowing what to do is not the important part, right? The important part is to implement. Like for example, you say if it is PII, then you know, we only store it, say for example, for 2 years, and then we destroy it using this wiping method, and then you know, we don't cache PII, for example, or you say you encrypt PII or you pseudomize it. Then the important part is to implement all of the stuff that you just said in your data protection policy and procedure. So that would take time and work, but you need to make sure you do this right, because that is one thing that would actually stop breaches, right? Write up procedures for consent and PII update and requests removal and stuff like that for right to be forgotten. So, you know, this doesn't need to be very technology based, but make sure you at least have a procedure for every time there's a request for it. If you can automate this, that's perfect and best, but make sure you test your automation. If you're automizing and there's data removal or request updates and stuff like that, you test them all the time. Write up an instant handling and breach notifications procedure so that everybody knows what to do when there's an incident and what to do when they're aware of it. Make sure that, you know, within 72 hours they reach out to the supervisory authorities, or they actually let the customers know without undue delay. And you know, all this kind of GDPR mandates for breaches and incidents is actually included in that. You have to also write a procedure for PIA, which is privacy impact assessment. Make sure that you know, for ongoing changes that is happening within the organization, you actually do a privacy impact assessment. So you know, you need to have gates for your project. So if one gatekeeper is if there is a PII before the design of the project is completed, you need to have a privacy impact assessment, and you need to update the privacy impact assessment as the project goes live, because there may be changes. And so this is very important to do, and this will show security and privacy in design for you, which is one of the big requirements for GDPR, and we talked about this. Make sure you audit and test your controls that you have implemented as part of your PIA within your systems or as part of your data protection policy. Appoint a data protection officer. So again, you can hire or you can let somebody else to take the role on, depending on the amount of privacy work that you have. You know, depending on how much changes you go through as an organization, how many, you know, privacy requests and, you know, calls and, you know, right to be forgotten, rights to are actually committed and stuff like that. Based on that workload, you can see if you need to have a data protection officer. And data protection officer is mandatory as part of GDPR. So it's basically they needed the data protection officer or DPO based on your scale of data subject or PII processing. So that is very important to them. If you have a high scale of PII processing, then you need a DPO. Or if you're monitoring high PII, then you need a DPO. So it actually don't say what they mean by larger scale. It just says that you have to have a DPO, and that probably means that you need to have a separate DPO or an individual who is dedicated to DPO role. And DPOs are responsible for educating the company and its employees and work on the compliance on GDPR. And they have to do the monitoring and audit of the GDPR and data protection activities and work based on the data protection policies and procedures. They have to maintain comprehensive records of all data processing activities. Also they have to, they basically serve as a point of contact between the company and supervisory authority in the member state. And then also don't forget to review your vendors' contracts. So, for example, if down the stream you are, you're using any vendors, like for example in the AWS example that I made here, and make sure that you go through the contract with AWS and make sure that they understand what their GDPR roles and responsibilities are to ensure your compliance and your compliance needs, not only theirs. They may have their own, but you need to make sure that your compliance needs are respected within the contract. So a lot of times, especially for now with AWS, it's a bigger contract and usually they're already covered. But with smaller contracts, make sure you go through them and you understand what they do with the PII you send them. In that case, you would be the collector of the PII and they will be the processor. And so make sure that this handoff of the PII responsibilities is actually working well for you. And then also awareness, and training. Don't forget that. This is very, very important, and we've already talked about this. About GDPR tools and resources, there's a GDPR official checklist that I put the link right here for you. Basically it's just go to ico.org.uk and search for GDPR official checklist as well, and then same link would come up. So it's basically it's a checklist that you can go through and make sure you've got everything covered. It's not written as it's not written in a lawyer language or law and regulation language, but it's very end user based and much friendlier, so it's easier to understand. Next thing is a free GDPR implementation Gantt chart that I put there for you. And this is actually free. It's from allbusinesstemplates.com. It's a GDPR implementation Gantt chart. So again, it takes you through the steps you need to do and actually what steps need to be parallel, what steps can be one after the other, and that sort of thing. So that is free. The other thing, the other one is the compliance toolkit, and that is also from allbusinesstemplates.com. I just put that in there. It's cheap. It is not free. Last time I checked, it was 55 USD. Again, I'm not an affiliate of this, so I'm not making any money here. Next one is OpenDLP, Open Data Loss Prevention. OpenDLP is a tool that is open source. It's a It's very easy to work with. And you can actually crawl your systems for PII or any type of information you want. Like you will understand what credit card information looks like, you understand what name and emails look like, it understands what physical addresses look like. So it will look for that type of data, and it understands how it looks like usually, so it can actually flag it. So you will know, where your PII reside and places where you were not expected. And make sure you use GDPR compliant CRM tools. And then the other tool that I have for you is called Opt-in and Transparency Layer. It's OIL or OIL, and the other tool is called Claro with a K. And they're also open source consent management tools. These are also very, very handy. So that you know where you're collecting your consent, how it's getting updated, and what are the changes to it, and and if different users or different clients have different types of consent, or your different systems have different consent, then this will be really helpful. And it is GDPR compliant to my knowledge, but they're also open source and free. Okay, so last words. Now I'm waiting for your questions. You can actually type that out in the chat box. I'll look at it in a minute. And also, I will go to the there will be a feedback form uploaded in the chat box. And then please keep in touch. You have my email address there. So please make sure you do that. Okay, now I'm going over to the chat box. Okay. So sorry, somebody's talking, but I don't know if it's a question or not. If it's not a question, please. Okay. Seems like there's not much questions here. Okay, perfect, everybody. I'll stick around for a little bit longer in case you have more questions, and I will share. Can you please share the slides? And yes, the slides or the whole thing and the presentation will actually be shared on LinkedIn. So please keep an eye on that. For internal user PIR, there may be other regulations required to hold the user PIR for a longer period. Yes, so the period of time, it's based on your business. So that's why I was saying that your business model is very important. And also different PII regulations exist based on the jurisdiction of where you operate and where you're storing your data. So different privacy regulations definitely have different data retention policies, for sure, absolutely. How important is this in terms of CISSP exam? I would say it is important, because CISSP exam does touch up on different regulations. GDPR is newer, so I don't know if CISSP exam has been updated since GDPR is out. So that would be a good question for ISC2. In case there is a request for yes, Chitan, I think I answered you. And then how an organization will be certified and who will do that? Okay, so this certification is actually very interesting. So as I understand, there's no certification as of today, and there will be a certification process probably soon. You can actually go to the ico.org.uk and read on that. And there's a section where it talks about certification coming up soon. But there is some third-party certifications right now, but I don't believe anybody is required to do so. I have not seen anybody getting certified yet. What if the user requests to delete, which is in coordination to the regulation? Yes, if the request if the user or the data subject requests to delete their data, you need to make sure you do that. Although your data protection policy may or data retention policy may be different, but still you need to make sure you do that, regardless of how long your retention policy is. What's your thoughts on employee requesting their data and employer want to keep it for legal matters? For legal, well, this is a legal matter. So if the employee is requesting their data to be removed, and they are an EU citizen, and they're actually operating in the EU offices, they are, so then in that case, you may want to delete that, remove that, because that is that will be a problem with GDPR. There is extensive discussions on what to, what type of record to keep when there is a right to be forgotten right exercised. So if this right is exercised, then, a lot of people say, okay, so for example, I want to say, for example, Adele has come to us and said, please remove our data. Then I go and remove the data, but then somewhere I need to say that Adele's data has been removed on this and this and this and this system, so that I know. And also, later on, there, if there is a complaint, then I can say that no, we have done the removal, and this is how we did it, and we actually did. So, but by that, you're keeping the first name and last name of Adele, or whatever information in the data removal record, right? And so that is on its own, it could be a PII data. And so that gets really, really interesting. There is no real response on this yet, but with a company, with one of my clients, what we did was, in the data protection policy, we did say there that we keep a right to keep the data of a removal record for a right to be forgotten. And also we said that if an individual is doing illegal activities, then we keep their information so that we know not to do business with them again. So this is how we've done it. Again, you need to run it by your lawyers, and the internal lawyers in that company agreed with this approach. GDPR follows. Sorry, I don't. GDPR follows which regulation or regulator? So GDPR is actually the regulation itself. So I'm not sure what the question is here. Is it applicable for companies operating outside EU? Yes, absolutely. So operating outside, but marketing or offering goods and products and services to the EU, still they need to be compliant. So if you have, if you're actually monitoring EU residents and citizens, or if you're offering them goods and products and services, and because of your offers you're keeping their PII, then although you're operating outside of the EU, you need to be compliant. What were the two principles you mentioned earlier in the presentation? There are actually few principles, there are not two. One is lawfulness, fairness, and transparency. The other one is purpose limitation. The other one is data minimization. The other one is accuracy, storage limitation, integrity and confidentiality, and accountability. And last question is, GDPR is only related to PII or others too? No, it is about PII, yes. Is it in the slides? No, it is not in the slides, Corinne, but I can actually write it right here. While I'm typing this, please let me know if there is other questions. course. Yeah, no problem. Okay. Okay. Well, I believe this is it. I don't see any more questions. Smitha, could you please make sure that you have sent the feedback form? Oh, perfect. Yes. So you can see the feedback form in the chat box as well. Yes, Corinne, sure, you can speak.
So, Deli, my question goes back to that question around employee requesting to remove their data. So, John Doe works for, I don't know, Chase Manhattan Bank for, say, 10 years, and he's left the company and he wants to remove his data, but in some level, the company has rights to keep your data for legal purposes. But he says, oh, I don't care what my Pi data remove. Identifiable data, social security, address, and so forth and so forth. And they remove the data per the GDP regulations. Then a year later, he applied back to Chase Manhattan and they have no record of him, but they mark the data removable. We don't want to do business with this person because they request to remove the data. You know, playing the devil's advocate here, how would that situation be handled?
Yeah, I don't know if you heard. Basically, first of all, I would definitely talk to your corporate lawyers because they would know the other regulations and other laws, and they can tell you which one should take priority. So, for example, you may want to keep the data because of, say, financial reasons, or to respond to your taxes and whatever else, right? And
Right.
then so that's a law, right? That's a law. But then GDPR is also another regulation. So the lawyers have to tell you which one is the should be the priority there, and then
Yeah.
based on the decision that you make there, you have to put that in your data protection policy and also in your privacy policy and consent to make sure that you let people know that in such cases you will be keeping the data for this long, you know.
Oh,
So that is very important, and that's why in the very beginning I did say that you need to make sure that your lawyers actually look at everything you do in GDPR and any other regulation and compliance effort you take.
yes, quite so, because in every regulation, you'll have whichever law take precedence, and also learning how to handle the exceptions, because you will have exceptions to all the rules. Thank you.
Yeah, of course. Yeah, no problem. So the
Ali,
last question here is
hi.
about. Hi, sorry.
Hey, it is Fahim. I have a question. What if I don't delete the data and use the anonymization or tokenization? Is it gonna help, or the deletion of the data is important? One. The other thing is, for example, I have another question. The other question is, if I hire a temporary contractor in the UAE and want him to do some work with me. So part of the regulation here in the US, I need to grab a couple of his information for money transaction and all those stuff. Is it gonna GDPR is gonna touch me for temporary contractor as well?
Yes. Oh, for sure. Yeah. Temporary contractor or not. If the contractor is an EU citizen and works and operates in the EU, then yes. Yes. And sorry, what was the first question? Oh, about if you do.
What if I don't delete the data? I don't delete the data and keep it and make it anonymized, or do a tokenization. Is it gonna help?
If you do tokenization, as long as the token doesn't go back to an individual data, or pseudonymization, as long as there is no data on the actual person. Yes, like for example, you can keep an say, for example, you have 10 people, right, who have bought product A, right, and you can keep the name of those 10 people, right, which is PII, and one of the 10 would come to you and say, you know, I want my data to be removed, right? So you remove their name, but you can keep the number 10. Like, for example, in your stats, you show that I've sold 10 of these products, not 9. You know what I mean? So that is called pseudonymization. That is when you still have the stats, you have the intelligence you need, right? But you don't keep the PII. Does that make sense?
Yeah, got it. Got it. So there is somehow workaround if we don't delete the data and do that tokenization and pseudonymization and all those stuff. It's gonna help somehow to some extent.
And still, I don't advise for it. It is not what you have to do. You have to actually remove it, right? You can, again, you can keep the intelligence or the, you know, artificial intelligence around it, as, you know, if you will, but you don't keep the actual PII. You can, you know, you can make it, for example, we had this question before where you know, an employee wants to leave the organization, but then you know, there's an admin account on a very old system that you know, cannot be changed, for example, or whatever the case is, right? You change the name of that person to a number. So you don't have that name anymore. You don't have their PII anymore, but it's a number, and then you can keep that. That's fine, but you have to show that now it's pseudonymized.
Got it. Thank you. Thank you very much.
Of course. And then the next question is for data security breach. Will need to be reported within 72 hours. My question is this to be notified from the time of breach or from the time we got to know it? From the time you got to know about the breach, from the time you became aware of the breach, that's when it becomes important, and you have to report it. You got 72 hours from then, because you know, everybody knows there's now you know, targeted incidents, targeted breaches, targeted hacks, where you know, the hacker may be within your systems for months, and you know, Equifax, for example, or different breaches like that, and they didn't know about it. But from the time you know or become aware of it, you have 72 hours to report. Okay. Well, that's it. Thank you, everybody, very much. I really enjoyed this. Hope you did as well. And it will be, the presentation will be uploaded to link to sorry, forgot, YouTube as well. And please keep in touch. My email is like Adele Farhadian @infosecassured.com. It will be great to see everybody. Thank you. Please don't forget about the feedback form as well. Thank you very much. Bye.